presentation, we will discuss the film 12 Angry Men, which was regarding the murder accusation against the 18-year-old young boy who has several past criminal records and lived in a suit in stepping 4 inches into the cheeks of his own father from the perspective of principle of relevancy and admissibility of evidence under the Common Law Principle and Evidence Act 1950 respectively. Before we discuss those principles, I will briefly explain the fact of the case in this film for better understanding of what happened in this case. This is World Racing Day. The occasion occurred at around 8 p.m. when the boy was having a fight with his father. The boy was hit by his father twice. After, the boy ran angrily out of his home and subsequently purchased a swing blade, which is peculiar and unique created. After that, he was drinking and hanging around with his friend from 9 p.m. until 9:45 p.m. Subsequently, at around 12:10 a.m., his father has been found murdered by the police after receiving call from the old man who lived downstream of the boy's house. However, we know that the father was murdered by a similar string bracelet which also owned by the boy, which at the same time all his friends also noticed that the boy brought back the string bracelet with him after hanging around with his friend. It is to be noted that there are two eyewitnesses in this film, namely the old man who lived downstream of the boy's home and the woman who lived opposite the boy's home. Both gave their testimony to testify that what they saw and heard at the material trial of the occasion. The old man testified that he heard a fight between the boy and the father, in which the boy yelled out, "I'm going to kill you!" After that, he heard a sound of body falling to the floor in the apartment above him, and saw the boy run out of the house. While the woman testified that she saw the murder took place by the boy through the window of the last two cars of the passing elevated train track. Support her testimony by describing clearly how the boy raising his string blade over his head and stepped down his father's cheeks. The boy, given that he has an alibi at the material trial when the murder happened, he acknowledged that there was a fight in between him and his father during that night. However, he was watching movie at 11:30 p.m. and only came back to his house at 3:10 a.m. The string blade also fell out of his pocket and went missing, wherein he did not realize the falling of his string blade until being questioned by the police. However, the boy neither remembered the name of the movie nor any actors in the movie, even though it is only a few hours after the movie ends and when he is being questioned by the police.
The first piece of evidence that is relevant to the charge in the film is the testimony of the old man lived downstairs under the room where the murder of the accused father took place. It was testified by the old man that he heard loud fighting noises at 12:10 of the night of the murder. He testified that he heard a sound of body hitting the floor after the accused yelled out, "I'm gonna kill you." He also testified that when he ran to open the door, he saw the accused ran down the stairs and went out of the house. He then called the police, and the police found that the accused father was with a knife in his chest when they came to the room. The testimony of the old man is oral evidence as defined under Section 3 of the Evidence Act 1950. as it is a statement given by the old man who had witnessed certain incident relating to the murder which is required by the court to be made before it. The testimony can be the oral evidence which used to prove the fact of the murder, as the old man had heard and saw the incident relating to the murder in pursuant to Section 60, Subsection 1 of the Evidence Act 1950. It can also be classified as circumstantial evidence, as it is not drawn from the old man's direct observation of the murder, and he merely heard the noises and saw the accused running away from the house.
With regard to relevancy, it is stated in Section 8, Subsection 2 of Evidence Act 1950 that the previous or subsequent conduct of any party in relation to the fact in issue is relevant fact. It is provided in Explanation 1 to Section 8 of Evidence Act that a statement is not considered as a conduct, but if it is accompanied with or to explain the acts, it is the conduct as meant by this section. In the case of R versus Bo, it was ruled by the court that in the prosecution of a murder case, the accused's previous word which show his feeling of hostility towards the victim could be the fact that he killed the victim. In the film, the words "I'm gonna kill you" shouted is a statement made by the accused prior to the estimated time of the murder of his father. This previous conduct could be an explanation to the sound of body hitting the floor heard by the old man, and it indicated the fact that the accused was hostile and had the malicious mind to kill his father. Hence, the statement could be regarded as the previous conduct, which is the relevant fact to the murder. Then, the relevancy of subsequent conduct can be seen in the case of Khairuddin bin Hassan versus PP. In this case, a car which carried drugs was intercepted by the police. The appellant was in the car at the time of interception, and he attempted to flee but was apprehended by the police after a short chase and scuffle. He then was charged with the offense of drug trafficking. The court held that the act of the appellant running away from the scene of offense is a relevant fact under Section 8, Subsection 2 of Evidence Act, which may be taken into consideration in determining whether he committed the offense. With reference to this case, the accused's act of getting out of the house after the sound suspected to be in connection with the murder was heard may be an act of running away from the scene of offense. It is a subsequent conduct of the accused which may demonstrate a direct bearing on him in committing the murder of his father. Thus, the conduct of the accused running away from the house subsequent to the murder of his father could be the relevant fact. So, taking into consideration of the points aforementioned, the testimony of the old man is relevant to the murder according to Section 8, Subsection 2 of Evidence Act, as it is related to the conduct of the accused prior to the murder, namely, he heard the accused shouted, "I'm gonna kill you," as well as the accused's subsequent conduct in which he saw the accused running away from the house after the murder of the accused's father was estimated to have been taken place.
Furthermore, the second piece of evidence against the accused is the testimony given by a woman who lived across the street from the accused. The woman testified that at around 12:10 at that night, she was lying in her bed, insomnia, and she saw the accused raise his arm over his head and stick the knife down into his father's chest through the window of a moving elevated train when she looked out her window. On a side note, it has been proved in the court that a person could see clearly what was happening on the other side by looking through the window of a passing elevated train at night. She further testified that it was 12:10 precisely, which matched the time of the accused father's death. The woman's testimony is oral evidence and can also be regarded as direct oral evidence. This is illustrated in Section 3 of the Evidence Act 1950, wherein her statement is considered an oral evidence where it was given orally by herself before the court.
To be more detailed, oral evidence is when the eyewitnesses has been called by the prosecution to present before the court to provide oral statement during the trial, as illustrated in an English case, ZAINAL versus Regina. According to Section 16, Subsection 1 of the Evidence Act 1915, evidence is regarded as direct evidence when it can be proved that person who provided this evidence is perceived it based on his own sense, as the woman in the film testified that she has seen the accused stab his father with a knife through the window of a moving elevator train at that particular night. While, pursuant to the same provision, it states that oral evidence must be direct, which means that this evidence is directly prove the fact in issues. Section 3 of the Evidence Act 1950 defines it as any fact that is by itself or in connection to other facts. Fact in issue also refer to the fact in disputes. Like in this villain, the woman testified that she in fact have seen the accused stab his father. Murder has found the fact in issue, which require the prosecution to prove whether the murder was committed or not. Section 9 of the Evidence Act 1915 states that facts that shows the time and location which is relevant to the facts in issue, it shall be explained and to be considered a relevant fact. In addition, if the woman could identify the accused and the time when the murder was committed, and the time given is corroborated to the medical evidence provided by the coroners, this oral evidence possesses a strong probability value in proving the guilt of the accused. As the principle can be seen in the case of Public Prosecutor versus Furman v. Fernie, when the eyewitness account was consistent with the pathologist's expert evidence. From the feelings, the time of the death of the accused father is fitted the time of the killing took place testified by the woman, which is 12:10 a.m. at that particular night. In short, the woman's testimony is relevant and her oral statement itself have found the facts in issue pursuant to Section 16, Subsection 1 of the Evidence Act 1915 concerning the murder committed against the father of the accused.
From this video, it is pertinent to know that there are certain values inferred from this verb after we have watched this film. We found out that law is a ruthless weapon with the objective to punish the offender. However, it did not intend to punish any innocent persons. Reasonable doubt is the standard which supplements the law to protect every form of life with due respect and relevance without distinctions. We need to respect the law and respect the life. Hence, people born in slums should be treated equally but not preconceived without relevant facts in the case. Besides, it is important to decide based on the facts, but not personal anger towards the crime committed by the accused. Otherwise, we will become a public avenger who only release our own feeling but doesn't uphold the principle of justice. Until human nature is hating crime, however, the law is the rule. Hence, we need to uphold the rule by ensuring that the justice of it and it is notable that truth is the tool to reach this objective. Apart from that, civilization is the only value retained by a human from the history. It is the value which can differentiate humans and the beasts. Merely venting anger towards the accused doesn't amount to civilizations. We need to keep scrutiny and sanity towards the facts and truth of the case. Otherwise, there is no difference between the beast and us. Perhaps we knew that an accused is innocent until proven guilty, and the evidence even is relevant into the facts of issue. However, the judge must examine the admissibility of the relevant evidence, as is such relevant evidence property values may prejudice to the accused, and that's a reasonable doubt arose from the relevant evidence. The judge must exclude such evidence in order to produce a fairness judgment. That's all from us. Thank you for listening our video presentations.